Senator Lang must have run across the street. I need my list. Gentlemen, I need my list. Okay, the first bill on the list is House Bill 91. Jessica, you ready? Okay. There's no one on the sign-up sheet. Is there a House member that's here to open or to introduce the bill? No. Senator Lang.
Mr. Chair, I introduce House Bill 91 relative to the presence of the fire department at fireworks displays.
Okay. Is there anyone here to testify on House Bill 91? Seeing none, close the hearing. That one will be an easy one to write out.
I think I can get that. I think I already wrote it. No, well, we got 10 minutes.
Do we have any other bills to exec or pending that we want to talk about?
I certainly can go into executive session, all those. Do I have a motion and a second to go into executive session?
So moved.
We have a motion and a second to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. We are in executive session. There's very few that we have out there. The advertising in newspapers, you do have an amendment for that, but
What's the bill number,
the
Mr. Chair?
words for notwithstanding the other fine section, the attorneys are telling me, yeah, it should be in there. And I'm looking at amendment 1510S. The other thing is taking out or at the end thereof. Okay, and so that's in the works right now. There's no pressure to do it. We might as well get the right one. Unless you guys want to put it through as a committee amendment, I've no reason not to wait till next week.
John,
No motion?
I was going to make a motion. If we have the amendment, let's take care of it.
Well, I don't have the final amendment, that's the thing.
So it's this amendment plus a couple extra changes?
Well, however she words the notwithstanding, why don't we just wait?
Fine.
Then we'll be able to see it. All right. $5.54.
So what was the other number we do?
554.
Oh, that's the one with Senate Bill 54. I'm a 45. And I think that somebody asked my aide about this, and I was too busy this morning to dive into it. So, yeah, we'll hold that one too. Okay. Other things that are going on. We're going to start the House bills here pretty quick. And I wanted to at least personally have a meeting with Secretary of State about those House bills and the things that are on them, things that could be revised, Right now, I've been getting a lot of complaints in the campaign finance that because we modified the wording about the $50 donations, which don't have to be recorded by name, but that's being interpreted that if at the Rochester Fair, if I have a kid who colors a button the parent also wants one of the military buttons or anything else that's on the table and gives me $1, I have to get their name and address. That's certainly a deterrent to people, doing that kind of thing. So we're going to be discussing, at least I will be discussing words, that make that more clear how those words are going to come out. I don't know. It may be something like, incidental items, for, that are, at a booth for donations or something, or could be even more sweeping that says, donations of $50 or less that are not intended to be recurring, because that was one of the issues that if someone gave $25 a month, for 2 years, that would certainly exceed the $200 limit. But, again, how far we go, that's one of those issues. The town elections where there was supposedly 100 people who, when they first presented themselves to register to vote, didn't have their birth certificates. I've spoken with the DMV. For people who have a real ID, they do have a checkbox whether or not they've proved citizenship to the DMV. I've asked, is that part of the download we get from the DMV to the Secretary of State? So we're checking on that, because if that information and election net information are available at the polls, then certainly we can accommodate a lot of our people who change from Manchester 3 to Manchester 12, or from Hooksett to Milan, or wherever. That, again, there's provisions in the law that already take care of them. And if that information is available, either on a tablet or by phone or whatever, that we should be causing less interference with our voters. I don't know if there's other things that you guys want to think about or whatever. Certainly, you got a little bit of time, or you can have your own meetings with the Secretary of State. So, but that's just to give you a heads up of things that I've been thinking of. Anybody else want to chime in with anything at this point?
Yeah, actually,
Go ahead.
we passed the bill with respect to the primary change to June. Ours was effective 1 of 26. The House is coming to us, or already has, is 128, 127 effective. Do you have a rough idea? I'm doing a budget in Manchester. I'm not sure. Our fiscal year is in July, so it would be 3 elections.
Again, I can't.
If it was 26, or in any sense of.
It's it's gonna, when that bill comes before us, we will look at the date.
Okay.
The difference in the dates was preparation time for the Secretary of State and other things. If a particular community had a problem, with that date being somewhere, you may have a primary in July, but you wouldn't have your general election till November, right?
Right, but like this year, we'd have another election if it was June, if it was 126 effective. So I need to increase the budget to the clerk for that 3rd election. But
Well, we'll have to wait and see.
Okay.
Take it out of contingency, right? Isn't that?
Oh, that's tough.
All right. Anybody have anything else to discuss in executive session? We still have, according to that clock, 4 minutes. According to this watch, we have 3 minutes. All right, seeing nothing, I'll take a motion to come out of executive session.
So moved.
All those in favor say aye. Aye. All those opposed, we're out of executive session, and I seconded that in case anybody was wondering. All right. We didn't get anybody new that wanted to talk on 91, did we? Good. Let's see, so how many people out there are smiling? Margaret's smiling. Oh, a lot of them are smiling now. Are you ready? All right, we'll open the hearing on our next bill, House Bill 230. That's from sponsored. Come forward and introduce yourself and her bill. For you guys, I wanted to bring a copy of Senate Bill 63 from last year.
Good morning, Senator Gray and members of the Election Law and Municipal Committee. Thank you very much for hearing my testimony. For the record, my name is Representative Juliet Harvey Bully, representing Belknap County District 3. And I just got some sheets passing around to you. This shouldn't take too long, but I just, this bill has been introduced in one form or the other since 2021, and I thank Senator Gray for his indulgence. It comes around once again. But basically, this is House Bill 230, and it's about how local public health ordinances are to be adopted in towns. When I introduced the bill, it was exactly as the Senate version passed from last year.
And I have provided copies to all the senators of the final version of 63 that was vetoed.
Oh, from last year. I also have a synopsis. I will get to that at the end of what happened to the bill over the years, just if anybody's interested. But it passed, this bill passed on consent in the House, and they amended it basically to a simpler version due to the fact that the governor had vetoed the version from the Senate Bill 63 that the chairman alludes to. And the reason for that was so the committee felt that it was a bit confusing, perhaps. They wanted to keep it simple. They felt that the language was fine as it has been amended. So it would just keep the regulations that a health officer may make to limit it to nuisances and not the very broad and other such regulations. So the reason for that is, so I gave you a packet on your first page here, is how the language appears in our statutes. And as you see, it's under the title of nuisances, toilets, drains, expectoration, rubbish, and waste. It's not about communicable disease and whatnot. And that is why I think the House committee felt that it should be limited and just keep it to nuisances. And if what was told to me by Representative Majori, that if they wanted to add a communicable disease paragraph, that should go underneath. I invited him to the, hopefully he'll send in some comments. But the thing about this regulation is that there is no, this part of the statute is that there's no requirement for a public hearing. And ordinances may be adopted during the course of a regular meeting without any notification. And so that leads us to believe that it is for something as simple as nuisances and not as something as broad as communicable disease, which is sort of what got this bill started in the first place was the mask mandates. And I'm not going to go through a lot of details about the mask mandates, only to say that, I've got a copy of the Hanover mask mandate here, and they do reference RSA 147:1, and it's quite extensive. Some of these were rescinded. This one in particular was rescinded and then came back a number of times. It doesn't have any particular end date. So that is the genesis of the bill, but it is about more than that. It is about these other sort of things that have branched out from it. So, for instance, the next thing in your packet is the ordinance number 40 from Hanover, which is about restricting home visitors. So during the COVID, if you look on the second page, I've highlighted where they are restricting gatherings in homes to a certain number of people and also requiring residents to keep lists of people. So that is they're using RSA 147:1 for that. So as you can see, that's sort of not just COVID. I know COVID's over, but there are other things that come up. And one of those other things is totally unrelated to communicable disease. But if you look on the next thing in your packet, this is a page from the town of Atkinson, their ordinance. At the bottom, you'll see that they require that if you are going to tattoo people for your business, you must be a physician. So that is, most people have found that is onerous. But they're going in that, this section of law here can be used to gatekeep businesses out of town. Here's another example in Albany, which you could still find this example right on their front page of their website. And it says, no person shall drink or possess any alcoholic beverages on any public street, highway, public sidewalk, bridge, everywhere, anywhere within the limits of Albany. That's probably a misunderstanding, or I'm not sure how that came about, that they decided to do that, or if they even enforce it. But as you can see, the problem is ordinance has sort of gone awry, for a lack of a better term. And so we also have an example of in Salem and some other towns where they're establishing license fees around tattoo parlors. So you might say, well, why not we allow zoning boards to establish fee structures, but we haven't allowed that in the municipalities as far as I could see. So really, I would like to see sort of a reining in of this section of the statute. So it's better defined, and we don't have sort of towns going off in different directions that don't seem to match this part of the statute. And so I've also given you the last thing is sort of a list of the history of the bill, the different languages. We've tried to approach this from different ways. The public hearing thing is one of the key things here is there's no public hearing. I had what I'm afraid of is I had a selectman in my town tell me in a public meeting that he would, if he could, enact a vaccine mandate in town. Just if he could do that, he would. That's illegal, but the thing is, sometimes people get alarmed from what they see in the news, and they want to pass ordinances to protect everybody. We want to keep that at the state level, which it is now. The governor can enact a state of emergency at any time, as he did during COVID, and that has oversight and checks and balances to it. And so that doesn't impede this. The governor can still enact a state of emergency. And that is one thing that kind of comes up that you'll probably hear about from speakers after me, is that, you know, what if there is a train derailment? Or what if how does this affect mosquito control? What about public, bodies of water? Well, that's all sort of in the statutes already. And I've listed some of these examples of where they are in the statutes already on the back. Partial list of laws and regulations. For instance, the public beaches, that's handled by DES already, and that's already in statute. Emergencies, the governor, there's a whole section of statutory law, that addresses that sort of thing. We got the bed bugs. We've got mosquito disease. That's already in the statute. That can be controlled by the town. Septic issues, obviously. That's already in the statute in other places. It's not here. So with that, I will open it up for questions. I guess that's it.
I think that the senators want an explanation of why the words or other similar threats to public health were taken out of the original version and amended by the House.
Okay, thank you, Senator Chairman. Yes, that's what I was saying in the beginning, is that they took a look at it. I explained that the governor vetoed the Senate's version of the bill, which had the other language in it that was sort of adjacent, nuisances and nuisance adjacent. And he said it was confusing. I explained that all to them, why it was, what Governor Sununu said about it. And they agreed that it was confusing. So they preferred just to keep it nuisances. So that's the best explanation I have, Chairman. I'm not sure that's more complicated than that.
Questions from the rest of the senators? Senator Lang.
Thank you for taking my question. So would you be opposed to putting that back in?
I am willing to work with the committee on whatever they so choose. Do you have any thoughts on it that you could share? I'm just out of curiosity.
So, if I may, Mr. Chair. So again, my question comes to those things that are a public threat, but not necessarily classified as a nuisance. So I'm going to use shutting down a water system or telling a boiling water of town, saying, hey, we have a problem with our water system. You should boil all your water. So they put out a notice of things like that as a public health official. If
That's
we do this
already in statute somewhere else and it's not an order. I'm not trying to
I'm
do a back
asking
and
a
forth.
question. I'm asking a question.
So those
again,
aren't like you can't order somebody to boil their water. They don't call it an order anymore. They call it a boil water. I don't know. Sort of suggestion. I don't know. I don't know. I forget the exact term, but like you're not going to find somebody for not boiling their water. But it's like, you know what I'm saying? Sorry.
So again, let's follow up. Just say we're in the middle of a drought and they put a water ban in, right? Because the water table is getting low. We have problems with the water. So the public health officer says this is a threat to public health, safety, and health because if we don't have enough water, we can't live. So we're going to put no water in your grass, right? And it goes out as a public health order from there because of the drought. Again, do you think that wouldn't necessarily be a nuisance, right? That not being able to water your grass wouldn't fall under that. So again, I'm trying to think of things that would be a threat to public health that, again, isn't a nuisance, but would require an action of an individual town. It may not apply to the Lakes region, but it applies to Nashua. So Nashua needs to do something. And so my question is, don't you think that we should give some sort of flexibility, especially if there's a public health issue, to allow a town to be able to have some degree of control of what's going on?
I mean, I can't argue with that approaching it from that angle. But I just want to sort of, this is difficult. This is a real challenge. This is a real head scratcher, because you have people in, I forget what state it is, New Mexico or whatnot, where the governor declared that gun control is related to public health. And so because a lack of gun control constitutes a public health emergency, this is where, this is where definitions are probably a little bit helpful. And I've included on the back of that page a definition about nuisances that was created in the 2010, it's on the back of something, 2010 Public Health Task Force, where they address this whole issue. And I'll send it to you. I'll send the whole document to you. But it's in 2010, they studied the whole matter, and they defined what a nuisance is. It's relating to the use and enjoyment of property. That was the definition that brought, broad strokes, what that is. But anyway, yes, I can see the need for, I know people are, they want to include things that might not be nuisances. So, I mean, I understand from that standpoint, and I will work with the committee. Those are some of the issues that you come up with. So I'm going to.
All right. We're going to move on from that. Any other questions from the senators? Seeing none, thank you very much.
Thank you very much.
Julie Smith?
Thank you, Mr. Chair. I support this bill, and the words that I had prepared to say are somewhat now not exactly what I will be saying now, having heard what the sponsor said. And a few of it was that her operative words often included the word town, and nuisances were mentioned, and the vice chair mentioned the worst city in the state. So that got my attention. My issue is mask madness. And the sponsor mentioned the denial of public hearings. And the reason why I decided to stay and wait for my turn at the mic was that when Mask Madness 2.0 was unleashed in Nashua in November of 2021, Alderman Wilshire, the keeper of the gavel at the time and still the present one, she denied public comment when that was on the agenda. And I was a Zoom participant, and I remember holding up something that I wrote in front of my computer camera, and I got kicked off the Zoom. So free speech is a problem, and not that this bill is about free speech, but the public comment thing. I support any effort to expand this to apply to cities. I know that 3 members of this committee live in cities. So there should be some sympathy, I hope. I don't ever want mask madness ever again at any level of government. And I do remember the chair telling the rest of the Senate on a Thursday of last month, I don't remember the date, that New Hampshire is not a home rule state. And so I want to remind the committee that and have it go on record. That if this bill can quash out future opportunities for mask madness, I support it. And I thank you for the time.
Questions from the senator? Seeing none, thank you very much. Looks, Wayne, I can't read the last name.
Good morning, Senator. Good morning, Chair, members of the committee. My name is Wayne Whitford, W-H-I-T-F-O-R-D. I represent the New Hampshire Association of Health Officers and here to present our testimony on that. I've got some speaking points and also some documents that I'll pass out that address health ordinances that have been enacted under 147-1. The New Hampshire Health Officers Association is opposed to House Bill 230, which proposes removing other regulations and so forth. Over the past years, there's been several bills introduced, which we've discussed. Health officers have testified against these bills. The health officers in New Hampshire have been successful in carrying out their public health responsibilities under 147.1 since it was originally enacted in 1981. The bill's been in place for 1940, since 1981 for 40 years. We do not see a need to change that legislation. It is well understood by the courts. It's well understood by the residents of the cities and towns. The recent amendment to 230 removes enabling health officers to quickly respond to emergent threats in the community. And we feel it's important that the health officers do have the authority to do that. Health officers, as you know, are the clerk of the Board of Health, the local community. The Board of Health is made up of the local select board. And as such, we have introduced to the select board, to the Board of Health, various proposed legislation, which I've passed out here, under 147.1, which discusses some of the things that happen under nuisances and other events that could be detrimental to public health. Passing this bill would impede health officers to make necessary public health recommendations and promptly address the emerging threats. It would also reduce the ability to decide themselves the best way to implement these. As you see from what we've passed away, several of the bills have to do with septic and so forth, and dealing with local issues like I come from Newbury, in Lake Sunapee area. There's several towns in this area have been very concerned about pollution of the lake through failing septic systems. Not only the lakes, but neighboring wells and the groundwater. Many of these bills deal with that. These ordinances deal with that and have been passed, at least in my town, following public hearings and public meetings of the local select board, which discusses the need for such ordinances in the town. This bill may reduce the local health officer and the select board from implementing these ordinances. As I mentioned, some of the proper disposal of septic, standing water, which could result in mosquitoes in the area and so forth. Growing issues concerned with PFAS contamination, lead poisoning, and so forth, would not have the ability to promptly address these through 147. In conclusion, current language of 147 is critical to ensure municipalities can respond to situations that arise. We respectfully reflect the committee to vote it House Bill 230 as inexpedient to legislature, as it seemingly innocuous change could have many untested consequences for the New Hampshire citizens.
Questions from the senators? Senator Rhodes.
Yes, thank you, Mr. Chair. Thank you for taking my question. So, a little unclear here. I tried to do a little research last night, but what are the qualifications for a health officer in the state of New Hampshire?
Health officers are appointed, are recommended by the local by the local Board of Health, which, as I mentioned, is the Select Board, and that recommendation is submitted to the Department of Health and Human Services for approval.
May I follow
I
up?
think actually that was changed last year.
To my knowledge, that has not been changed. We have people from Department of Health and Human Services. Has there been any change in that?
You don't get to ask the questions. I do.
Okay.
Go ahead, Senator Rutherford. I'll get to you if you want to
Yeah.
testify later.
I was going to answer the question.
I'll get to you
Okay.
if you want to testify later. Thank you.
Follow up, Mr. Chair. So, as I understand it, what you just told me, there's no actual requirement that the public health officer or the health officer has any background in public health.
That's correct.
Okay, thank you.
Any other questions other than me? Okay, some of the examples that were introduced by the prime sponsor, do you think all of those actually fell underneath the purview of the statute?
I tend to agree that they would not.
And how do I rein the health officers in if they are making decisions that are not part of or are authorized by the statute?
Well, my feeling, as I mentioned, in my community, this is something that any of these recommendations from the health officer go to the Board of Health in a public meeting. There's an example of the one that we put in effect in Newbury, which showed we had 2 public meetings plus 3 select board sessions where the proposed ordinance was discussed. So there is ample public notice of these and support. There was support from the community in all of the public meetings.
Okay, any other questions? Senator Lang?
Is there any process for the citizen to repeal an ordinance or file a petition and vote on an appeal or?
It would be handled the same way. They would have an issue petition as they often do. That would go to the select board and it would follow the same process under public meetings. And it could be repealed that way.
All right, seeing
Thank
no
you.
other questions, thank you very much. Margaret Burns, and it looks like I may have another sheet up there on this bill.
Good morning, Margaret Burns, representing the New Hampshire Municipal Association. I agree with the testimony of the prior speaker and wish to just add some additional comments on House Bill 230, which is a bill that we oppose. The major concern with the bill as amended is the question of what exactly it does and what the language means with the words stricken in line 3. Currently, the way that the statute reads is that health officers have the authority to make regulations for the prevention and removal of nuisances, and other such health or regulations relating to public health as in their judgment and the health and safety of the people require. So that language in the second half of line 3.
Just a second, Margaret.
Sure.
Are you reading from the amended version or the as introduced version?
The amended by the House version that I picked up on the table. The language as in their judgment, the health and safety of people require really modifies that language that's been stricken by the bill. And so it seems to sort of hang out there with a question of what it would mean without that language included in the statute. So that's something that would need to be clarified. I know too, or I've heard too, that the motivation behind the bill is to clarify existing health officer language in the statute. And for that reason, I don't think that it does that. I don't think we get the clarification that people are perhaps looking for. In addition, that language that's stricken, other regulations relating to public health, taking that out would make the language in 147.1 somewhat inconsistent with other sections of RSA Chapter 147. So Section 3, Section 4, and Section 6 of RSA Chapter 147 all refer to other causes of danger to the public health, other things that are injurious to public health, other things that would cause injury to public health. So other sections of existing RSA Chapter 147 refer not only to nuisances, but to other things that would be injurious to public health. So I think that this bill would make this section somewhat inconsistent with other sections of RSA Chapter 147. For those reasons, we're opposed to the bill. I think there's even a question here because the term nuisances is not defined, what exactly would be left or what exactly health officers would have the authority to regulate under RSA Chapter 147. And so that leaves some confusion and lack of clarification in the statute as well. finally, I know there was a question asked by the prior speaker, and it is RSA Chapter 128 that allows the Department of Health and Human Services to make the appointment of local health officers upon the recommendations of the governing body. Looking quickly through RSA Chapter 128, there is a requirement for a background check, but I don't think there's anything specific to the qualifications of health officers, although a representative of that department can certainly speak more to that than I can. Thank you.
Okay, questions from the senators?
Thank you, Mr. Chairman. I'm just going to ask you, I mean, obviously you're involved with the municipalities. Do you think that health offers, there should be a qualification that health officers have some background in public health?
It certainly has logic to it.
Especially considering the broad authority they have, wouldn't you think that?
Be difficult to say no to that, Senator.
Thank you.
Other questions? Then it's my turn then. Addressing your concerns about removing the language about and other such regulations relating to public health, that is the reason why I believe the Senate attorney asked us to put in or similar threats to public health. Doesn't that, if those words were put back in, doesn't that, take care of your problem with the other parts of the statute?
So last year's bill, by adding in similar threats, it was saying that it would apply to nuisances and other similar things to nuisances. So I think that bill also raised the question of what exactly are other things similar to nuisances. Now, you can make the argument that nuisances, the word nuisances alone in the statute covers not only things that interfere with other individuals' use and enjoyment of their property, as well as anything else that affects public health, safety, and welfare. Because if you look up the definition of nuisance as a legal term, it does tend to include both items. So I don't know that last year's language or this year's language clarifies perhaps what the intent is with clarifying this statute. And if it's about something very specific, if the motivation for amending RSA Chapter 147 is about something specific related to COVID, then it would be more clarifying to focus on that than to broadly change health officer authority. I'm not advocating for that, but certainly since versions of this bill have been introduced over the past few years, most of what we've heard about is response to COVID regulations.
Okay, last thing, would you believe that our attorney said that I didn't need to put in the definition of nuisances because there is a multitude of case law that's out there?
I agree with that. That is certainly what a judge or an attorney would look at for a definition of nuisance.
Senator?
Thank you, Chair. Just picking up on your comment, Margaret. I mean, haven't we heard testimony that unforeseen situations just like COVID are exactly the reason why we probably shouldn't change this statute, because we can't foresee all the things that health officers will need to do?
That's exactly why the and such other regulations relating to public health language is in there. I know that the title of the chapter is toilets and drains and expectoration and other disgusting things. It doesn't specifically list out a multitude of other possible health issues, but certainly when the legislature adopted RSA Chapter 147, they understood that there would be things that municipalities, local health officers could not see coming. And they planned for that with the language that's in statute. So all that I would ask this committee is to ensure that the ability of health officers to respond to unexpected health threats would remain in statute, and that would not be taken away at the local level, where it's easier to respond quickly than it is necessarily at a centralized state level.
Senator Lang?
Would you be opposed to language added to the bill that makes those orders temporary and have to be renewed on a more regular basis? So that it's not a permanent, I create it and it's just there forever until someone decides to repeal it, but say that any regulation made due to a threat to public health, would only last for X period of time and must be renewed by the selectmen?
If the renewal continued to be through the same process as current RSA Chapter 147 has for the adoption of health ordinances, I would be willing to work on that with this committee if there was interest in that.
Thank you.
Additional questions? Thank you very
Thank you.
much. Mr. Johnson? As far as I know, we did put a bill in that changed it slightly. I'm not sure whether that bill passed or not, so she's gonna tell me. Hit the button.
Thank you, Senator Gray, and thank you, members of the committee. My name is Sophia Johnson, and I'm here to respond to Senator Rochefort's question about the bill that had passed last year. In the legislature last year, there was a bill that did pass that allowed municipalities to maintain control over the background check part of the health officer appointment. The department remains the appointing body for health officers, but the background check requirement is handled at the local level, so the municipalities can determine what would be necessary for the grounds of removal of the health officer or not appointing that health officer based on whatever they found in the background check. This
Questions? Senator Rochford?
Couldn't help. Thank you, Mr. Chair. So has there been a case where this really goes back to, and I apologize if I'm getting off of the track a little bit, but there's a lot here. Has there been cases where the DHHS has denied a candidate for lack of qualifications?
Not to my knowledge.
All right, thank you.
Thank you.
All right. Seeing no other questions, thank you very much. Is there anyone who signed up or didn't sign up and has changed their mind? Seeing none, do I have the count sheets? Yes. On the previous bill 91, I didn't read the counts. It was 0-0. Nobody signed up online. You can take that one. Oh. Is this the next one? Okay. And on this bill, there were 204 in support, 6 opposed. Okay, and with that, we'll close the public hearing and we'll open the next one in just a minute.
Okay. Senator Long. Crime bill.
We'll miss you. You can see us on video.
He is, yeah.
Okay. Is everybody ready? Okay, we'll open the public hearing on House Bill 265. There's no one on the list. Is there anyone here to introduce the bill? Seeing none, I'll introduce the bill. This hearing is on 265, requiring public body minute meetings, including start and end times of the meeting and the printed name and signature of the recording secretary. Okay. Is there anyone here that wants to testify on the bill? Seeing none, we'll close the public hearing. And All right, we'll open the next one in just a minute. Oh, on the one that we just had, the count for people signing in were 2 in support and 1 is opposed. Those were the online numbers. Okay. And I'm still on time, so the next one is House Bill 421. And it does look like we have the prime sponsor here to introduce this bill.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Mark Pearson. I represent 3 towns in south central Rockingham County. For the past 30 years, I have led 4 faith-based nonprofit organizations headquartered in Kingston. It had been the custom for decades, if not centuries, that religious, educational, and charitable organizations are granted local real estate tax exemption for the properties and land used for their specific purposes, but do not usually receive an exemption for properties owned simply to gain money for the organization. Several years ago, there was a court case, a town, like I like to say, north of my district, but they all are, that was suddenly, the tax exempt status was taken away for some of their properties. This went to court. The organization lost, the town won, because, well, perhaps things had gotten a little too broad. This action alerted towns to the fact they may have similar properties in their town. Towns that historically had been given tax exemption for real estate taxes, but maybe shouldn't have been. It also kind of pointed out that a lot of the relationships between these organizations and these towns had been what sometimes has been called gentlemen's agreements, entered into with a handshake 100 years ago by a town official and an organization official, and it made perfect sense and nobody ever questioned it, but not much was ever written down. So with this lawsuit being decided in favor of a town, many towns hired an organization to start to look at who exactly is getting tax exemption and who shouldn't be, perhaps. It was noticed that in some cases, Forms A9 and A12 had not been turned in by the deadline. It was also noted that the towns didn't always send out those forms in an appropriate time way as well. It was all kind of squiffy. But I recall when I was 2 years late with a form to the Secretary of State, Bill Gardner said, well, Mark, if we came down heavy on all the charities in the state, half the charitable work would go away. Having said that, get the form in, do better next time, which I agreed to all of that, and we have. So as a result, this bill is the response to the squiffiness. It tells towns you got to do certain things, or the organization maybe isn't immediately liable. But it also says to the organization, here's some responsibilities you have. So this is an attempt, with me having been taxed for $8,000, which was returned. We had a nice chat. Kingston is a wonderful place to do business. We all admitted, maybe we got to get some of this stuff written down. And with Kingston and people from a few other places, numbers of people asked me to put a bill in, and that is the bill before you.
Okay. Other questions from the senators? All right. We ought to be really all you've really done is you added section 1 And then in section 2 and 3, you changed the words, the local tax rate has been approved for that to March the 31st, the end of the property tax year.
Senator, may I suggest that we look at lines 7 and 8? The forms shall be mailed no later than 2 months before the due dates of the completed forms and supplemental documents. This wasn't done to us last year. There were new people in Kingston. They didn't know they needed to do it, and they didn't do it. And such is life in a small town. We got it worked out. But what it says is then you can't turn around and come at us until we get those forms from you. And the reason for that is most nonprofits don't have lawyers on their boards. I mean, the bigger ones do, the little ones don't. They are too busy trying to do the charitable thing their organization was founded to do. And I must admit, I should have known better, but I didn't. I didn't get the forms in. And so as a result, I was penalized for it. They remitted the penalty. Thank you. This just says line 7 and 8. The towns have some responsibility in this as well. And again, this is not to be punitive. This is just to kind of put some things down on paper that hadn't been really much before.
Further questions from the senators?
I have this one.
Senator Turner.
Why would it be the responsibility of the town to do this? Why is it the obligation of the person being taxed for their responsibility? They're the ones looking for the exemption and wanting the exemption. Why are we putting an onus on the town?
Well, I'm not sure how much of an onus it is, but for the previous comment, a lot of these organizations just, they do the best they can in the charitable work they do. One of the organizations I discussed had land on which they grew vegetables that they gave to the town for the feeding program. And then they discovered, now we're being taxed, we're helping the town. And the idea was nobody there kind of knew it, or they did, but they forgot, or the lady who did it retired, or what have you. And it is trying to make this a cooperative venture, because most of the charitable things benefit the town or some of the townspeople.
Again, I'm not saying they're not good charitable organizations are doing good work. Again, my question is, if they're the recipient of the tax exemption, why is the town's responsibility to remind them that, oh, you need to do this?
It'd be a nice thing to do in your town when everybody tries to get along. Point one, point two, as Bill Gardner, and Bill Gardner, I was 2 years late. He could have dropped the hammer on me. He could have fined me. He could have kicked me out of the state. He could have done anything. He just simply said, if we did that, we'd lose half our charities. And so he saw the need to the state, and I would argue the town could see the need for the town to have this charitable organization do its good works there. It's, let's be friends, which is kind of a way of answering your question as best I can.
Other questions from the senators? Seeing none, thank you very much.
Thank you, sir.
Ken Robershaw.
Great. Good morning, Chairman, and also good morning, Senators. Thank you for allowing me to speak here today. For full disclosure, I'm the town manager in the town of Raymond. The selectmen, the town of Raymond, oppose 421 in line 7 mostly. We believe that it's not on the onus of the town to keep track of tax exempt organizations. With this addition, it will allow taxpayer funded employees to keep track of these not-for-profits and tax exempt organizations. And my employees already have enough on their plate to keep track of another organization that is tax exempt, and is the onus should be on the organization and not the town. So the town of Raymond definitely opposes this bill, especially line 7.
Questions from the senators? Senator Lang.
So would you oppose if we made a requirement that you just instead of mailing to every single charity within your community, that you strictly 2 months prior, you must post in a manner similar to public meetings in your locations that these forms are due?
Yes, well, I wouldn't mind doing that.
You,
That would be,
you would object to that as
No.
well? You would not
Nope.
object to
as long as it's on like the town website, is that what you're saying?
however you post normal public
Yep.
meetings, right? To
Absolutely.
places, yada, yada.
Additional questions? Seeing none, thank you very much.
Thank you.
That's the last person that I have on the list that wished to speak. Is there anyone who's changed their mind? Seeing none, there was one additional person on the list that was opposed to this bill, did not wish to speak, and there were 2 opposed that signed in online. And with that, we'll close the public hearing, and we'll open the next one in just a few minutes. Thank you. Okay, and with that, we'll open the public hearing on House Bill 426. And Representative, are you here to introduce the bill?
Yes, Mr. Chairman.
Introduce yourself and the bill, please.
Good morning, Mr. Chairman. My name is John McDonald, and I represent Carroll District 6, which is the fine communities of Wolfboro and Tuftonboro. I want to thank you for the opportunity to present HB 426 to the committee. This bill and amendment, as presented, will help a very important group within our state, those being a group of nonprofits that are part of the hundreds of nonprofits that are located throughout our country. Those nonprofits provide educational, health, and social services to our citizens' needs, wants, and they deserve. Nonprofits fill the void which our local municipalities cannot provide for. Our last session introduced a bill that would allow the Board of Selectmen to ensure that they could accept late filings from nonprofits based on accident, mistake, and misfortune. The bill was passed by the New Hampshire House and New Hampshire Senate and eventually signed into law by the governor with an effective date of April of 2025. Prior to the passing of that bill, I was unaware of any accepted reason a nonprofit could give to prevent the late filing penalty, causing the nonprofit to pay their full tax bill. This bill should be considered a bridge for our nonprofits who are required to file before June 1st, 2024 and April 2025 and were late in filing. This bill will allow nonprofits the opportunity to justify their lateness being due to accident, mistake, and misfortune before the elected Board of Selectmen to ask for an adjustment on the property taxes. And if denied, will also give them the opportunity to appeal to the Board of Tax and Land Appeals or the Superior Court. In coming up with this bill, I worked with the Board of Tax and Land Appeals to try to get the correct wording. It's my understanding that they can't come and testify in support or against it because they're in some type of litigation with some other towns based on the taxes, but they did contribute to the writing of the bill. I hope you view this bill as common sense and reasonable and will allow our nonprofits to not be hurt financially and to continue to do the fine work they do within our communities and state. Thank you.
Questions from the senators? Senator Rocha.
Thank you, Mr. Chairman. So do we have an idea? I mean, this is going back retroactively. Do we have any idea how many of these nonprofits and charitable organizations would be affected by this if this is enacted?
I don't. I was hoping someone from the state nonprofit group was here, and I don't know if they're here or not, but I know my community there's 2. One is the taxes are going to be about $50,000, and the other one is about $3,000.
Okay. All right. I've got more questions maybe, but I'll wait.
Okay.
Right. Thank you very much. Seeing no other questions, we'll go on to Representative Pearson.
Thank you.
Thank you, Mr. Chairman and members of the Senate. I think the key here is in line 5, accident, mistake, misfortune. These are nonprofit organizations with volunteers. They do the best they can. They may need some prodding. And if it could be said that anything having to do with this would, and I quote someone, employees of the town having to keep track of tax-exempt organizations, they do. It's part of their job. They read over the A9s and A12s that I have to fill out. They come and look for you if you didn't do it right, if there was an error, if a form was missing, to say this bill and its predecessor hearing would require employees to keep track. Yeah, it would. Groups that are made up of volunteers, not necessarily knowing this, they need a little bit of help. They're giving a lot of help to the towns. That town can give a little bit of help too.
Questions from the senators? Seeing none, thank you very much. Peggy? Give it to the aide.
Thank you.
And if you were providing copies of your testimony, the Senate rules would request that you paraphrase it, not read it.
All right, thank you very much. Thank you for everyone for hearing us out today. My name is Peggy Henley Maniatis, and I'm the Executive Director of the Wright Museum of World War II. We've been a nonprofit organization for 30 years with property in Wolfboro. As a nonprofit organization with real estate presence, we're required to file the A9 and A12 each year pursuant to 72-23. Until a year ago, House Bill 1065 was passed in the amended RSA 7223. There is no provision for late filings due to accident, mistake, and misfortune. The museum is a small organization, and we provide a vivid perspective on the profound and enduring impact of World War II experience on American society. The museum has 3 full-time staff and part-time seasonal staff. The Wright Museum filed its A12 correctly for many years. The museum's June 2024 filing was late due to a serious family medical issues experienced by the staff member charged with putting the paperwork together for that. And as well as that, as we had a seasonal worker who fell and was unable to come to work, so she was required to fill in for that position as well. At the time, for several years, in the filing only contained a listing of board members since our financial statements were not available on that due date. We had filed an extension for our tax return, and the financials were provided later in the year with the extension. During our appeal to the Town of Wolfboro Board of Selectmen was sympathetic to our situation since we are an economic driver in our community and we attract over 18,000 visitors each year to the town who spend money on hotels and meals and retail shops. However, since the effective date of H. Bill 1055 was April 1st, 2025, the town attorney did not support the board's recommendation to grant us an extension. As a result, the museum lost its tax exemption for the year with a cost of $50,000 in real estate taxes. This is more than 10% of our entire budget for the year. Given the circumstances described above, it seems to be a very severe penalty for one late administrative filing fee. And we know that we were late, and but there was extenuating circumstances for that. Thank you.
Questions from the senators? How much was your tax that was,
$50,000.
and that's probably the 50,000 that the representative mentioned?
Yes.
Okay.
Thank you.
Thank you. And the last one who signed up to speak, it looks like the last name is Prizio, and I can't read the first one, so.
Apologies for my handwriting. Good morning, Mr. Chairman and Senators. My name is Salvatore Prizio. I'm the Executive Director of the Capitol Center for the Arts right here in Concord, New Hampshire. The CCA, nonprofit arts organization venue, in addition to what I do for them, I also serve on the New Hampshire Center for Nonprofits on their policy committee. We're one of the state's largest cultural institutions, and the CCA has been the cornerstone of New Hampshire's creative economy for over 30 years, hosting thousands of performances, educational programs, and community events annually. Our mission is not only to entertain, but to enrich the life.
We don't need to know more about any particular organization, okay? We need to know why you want the bill.
Okay. So very long story short there. This past June, we filed the first part of the tax exempt status in April on time. And in June, I was away at a conference, and my assistant, who usually files these, was at a medical emergency with their spouse who had suffered a heart attack. When she realized that the second piece of this needed to be filed, she reached out to me, but obviously I couldn't sign the paperwork because I was away at a conference. So when I got back, I signed it. We filed it. It was 5 days late. We tried to appeal to the city. We tried to appeal throughout the state, but as currently constituted, we owe the state or the city of Concord $150,000 in property taxes. Now, I am totally amenable to owning our mistakes and taking responsibilities for what we do. But even on a federal level, if you're late on your taxes, there's a penalty, not a, total, like owing exactly, going from 0 to 100%. There is a percentage that you would have to pay of that penalty. We understand the responsibilities of what we need to do in order to play our part in the city, but I feel that something like this is incredibly punitive and damaging to an organization like ours. Putting all of the mission statement and all of that aside, we draw 100,000 people to this city every year. For every dollar or for every ticket spent, there's an additional $35 spent in this city. We represent a lot of economic activity for this city. We just feel that this particular rule, as currently constituted, is incredibly punitive and damaging to organizations like ours. And it prevents us, that $150,000, if we have to pay it, is going to take away from a lot of our community outreach activities that we do that benefit everybody in this city.
Questions from the senators? Seeing none, thank you very much. And there was one additional person who signed up in support, did not wish to speak. Online, there were 4 in support, 1 opposed. And is there anyone who's changed their mind? Seeing none, we'll close the public hearing. And I'll take a motion to go into executive session.
So move.
We have a motion and a second to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. All right. Do you want to go backwards?
The chair's wishes up.
All right, let's go backwards. Okay, the reason I said if we go backwards, this is the one that's most, certainly the way this bill is written, it's chapter law. At least appears to me to be chapter law, because it's retroactive and it only covers the 1 year. It is notable that the lack of people who were opposed to it, okay, did not get testimony from the cities or towns that I know of. I don't even think I got any emails on this. I don't know what the rest of your experiences are. Comments from the senators?
I'll move on to pass.
We have a motion of ought to pass by Senator Lang, seconded by Senator Roseford. Further comments? All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it.
Move consent.
We have a motion for consent and seconded by Senator Perkins Quokka, seconded. All those in favor of consent say aye. Aye. All those opposed say nay. Does anybody particularly want to take this one out? I'll take it then.
You're taking out.
Yep. Okay, moving on. House Bill 421. Certainly the only contention that I really saw in this one was whether or not it should be the responsibility of the town to send the notices out, or whether it should be the responsibility of the person. Senator Lang did offer a suggestion where they could post it. I don't know that that really is going to solve anything, because now the town is going to forget to post it. So I guess I'm waiting for comments from you guys.
Mr. Chair, again,
Oop, here. Just a second. I can fix it.
there we go. So again, I understand the late filing problem. My concern was the amount of work we pile on municipalities. And this now requires, in a small town like mine, this might not be a heavy lift. It's only going to be probably a handful of charities, but I can imagine the city of Nashua might have, or Manchester might have a much bigger problem trying to get notices out to all the charities that are there. So that was my effort, the amount of work that's necessary from the developer to for the documentation, and that if there was a way of doing it in a more broad statement, like a notice in the paper and a typical way they notice meetings kind of thing, that might solve the problem, to remind the charities saying, hey, your form's due in 2 months. So that was my concern. Again, there's also a cost mechanism to this, right? So again, the city of Manchester sending out notices to a few hundred charities that might exist in the city of Manchester is going to be a costly process compared to posting a notice. Even a notice in the paper, probably cheaper than mailing everything out. So that was my thought, was around that area. Is I'm more than willing to remind them. The question is the methodology in which we remind them.
Further comments? All right. Senator Lang?
Rebecca.
Yeah, I guess I'm sort of on the fence of whether to comment. I mean, I largely agree. I guess it's sort of hard to know what the best way to solve this problem is. I guess I would sort of wonder how folks are made aware of this requirement, and I don't know enough about that, and I don't feel like that was necessarily revealed by the hearing. So I'm sort of in the same place, wondering whether the town is the right body or not.
I guess certainly the notice of taxation that's sent out, or the tax bills that are going out, could say your next report is due sometime, I guess. It's being the engineer in me, I probably make it a program, and it gets sent out automatically or whatever in the emails. So I guess we don't have a consensus on it. I'm going to let you stew on it for a week then.
If I could, Mr. Chair,
Certainly.
just comment. I want to be empathetic and sympathetic to the prime sponsor and the presentation that was given, but I mean these forms are fundamental to the status of these organizations. I would think. I mean, whether they're getting a tax exemption or not, I don't personally. I don't see that it's a heavy lift to get them in on time. So I'm struggling with that. I mean, we have people whose professional licenses are due on time. Our income taxes are have to be done on time. Our cars have to be inspected on a certain date. I mean, I think this just kind of goes with the territory. And yeah, for now. And I did that on purpose. So I just just to what Senator Lang was saying, I mean, this now puts the burden on somebody whose business this is, putting it onto the towns and municipalities to do this. I'm just not sold that this is necessary. at all. That's where I'm at with that.
All right. Yes.
Thank you, Mr. Chairman. I know in the city of Manchester, they, the tax collector, called me and told me I got 5 or 6, tax exempt, businesses that aren't filed yet, and they got 10 days to do it. So they'll usually call the alderman to call that business in their ward to say, hey, you gotta make sure you got 10 days to put this in. And that's been working well. I don't know of anybody in my 16 years in Manchester that have missed the deadline.
So I guess the way I look at this, if this bill says, and the existing law now says that you can file them late, they don't file, they get a tax bill, and they come in and say, hey, please forgive me, and they go on about their business. So if that's reality, okay, then the organization, by not filing, is creating their own hassle that they have to go through. Be that because of, travel, medical conditions of employees, or whatever. I'm still gonna let you stew on this one for a week, and hold it till at least the 15th. And so think about it, and we'll go from there. All right. Still going backwards. 265. I guess I have a problem with signature. Okay? The approval of the minutes, and I think I talked to Senator Roachford about this, the approval of the minutes come from the organization, okay? That the signature of the person who took those minutes, what does it matter? I mean, even if I didn't even have the name on there of who took the minutes, what does it matter? Comments from you guys?
I concur with that. I agree. I mean, I don't mind. I mean, the name is, I don't think, a heavy lift, but the signature, I don't see what purpose that serves, especially in an electronic world that we live in. I don't think that that's necessary, and I would agree with everything you just said.
Mm-hmm. So at minimum, I would like to take out and signature.
Yeah, if I may. I agree, because there may be somebody doing the minutes, and then somebody else who's producing them, going over those minutes, and it'll be correct. Like, it could be an assistant clerk taking the minutes, and then somebody in the department that's typing up the minutes. So, and it's asking who's producing the minutes. So who produces the minutes? Is it the original minutes as the producer, or is it the person that's typing up the minutes from an audio? And that would be confusing, because the final minutes producer is the last one that actually wrote down the minutes. So I agree. Taking out the signature, it's not necessary.
Anyone want to go any further? Because part of your argument would argue that the name isn't important because it could be a multiple people that actually produce this thing.
So again, I have no problem with the name, and I would go with the assumption it's the person that presents the minutes to the board, whoever it is, regardless of who took the minutes or anything else. It's whoever typed it up and gave to the board. This is the minutes. That's the name of the person I want, because they're the one representing. It's an accurate representation of what happened. is that person, the last person to touch it. So I think the signatures are relevant. As long as you have a name, if you want to backtrack something, you should be able to do that. So I would support if we were to pass this, to striking and signature and just leave it in the name of the person who produced the minutes.
Can I go back to what I was saying, Mr. Chairman? Why do we need this at all? I mean, we haven't heard any compelling testimony that says we need it. Nobody came to show up, but nobody showed up to testify. Why do we need this? And it's kind of a rhetorical question, but I know we're kind of taking it, going on the assumption that we should probably do something here, but why do we have to do anything at all? Is the state any worse if we don't pass this law?
Again, I'm getting input from you.
Right.
Remember when I said that I want to strike at least and
Yeah, at least. Okay, all right.
I didn't limit you.
If I may.
I'll go ahead.
Yeah, I think start time and end time is important, because some people like to check the minutes to see, wait a minute, when I wanted to speak, they wouldn't allow me. What time did this meeting start? So they want to know what time the meeting started and what time the meeting ended. I think to the public, it's important for them to know, to see, an 8:00 meeting started at 8:07, ended at whatever time. Maybe, so I got there at 9:00, it ended at 8:59. Okay, I was late, so I haven't seen any minutes that don't have the start and end time,
I can go either way.
Yeah.
I could kill it, I could pass it.
All right. So to get the thing going, I will move ought to pass.
I'll second.
Senator Lang. And then we have a committee amendment to strike on line 10 and signature. And I will move that committee amendment.
Second.
Okay. Further discussion? The secretary, I should say, our aide, would you read back the amendment?
Strike and signature off of line 10, from line 10.
Okay. Everyone understand the amendment? All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. I have a motion for consent.
Moved.
Senator Lang moves.
Second.
Did we voted on the amendment? Did we
Oh, we
vote
have to
on the
vote
bill?
as amended.
Bill as amended. You are
Catch.
correct. All right.
Good catch.
All those in favor of the bill as amended say aye.
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 All those opposed say nay. The ayes have it.
Move
Could have
consent.
had the big speech.
I know. It's like, I'm not going to die on this hill.
I'm just teasing you.
Yeah, I can
This
take that
is-
out,
And we
Mr.
have a
Chairman.
all right, you're gonna take that. All right. All those in favor of consent say aye.
Aye.
All those opposed say nay. And Senator Long will take it out.
We'll save that for carbon credit.
Okay. Certainly, House Bill 230, certainly the sentiment from the people who suggested this bill go back to that. And Senator Roachford even had a different one, I don't think that was discussed, is that one of the health officers banned kids from playing basketball during COVID because they touched the ball, and that could be transmitted to the other kids who were playing basketball. Certainly, it does not deal with trash or expectoration or whatever. So there is. I still do like the words of the Senate attorney better than the words as passed by the House. Comments from you guys?
Mr. Chairman? So I like the bill in the original form, but I do think it needs a couple modifications. What I was thinking I would do, develop an amendment would be, on line 2, put a semicolon after word for, and say that the town health officers may make regulations for, and then colon, put a number 1A, whatever the proper nomenclature is, the prevention and removal of nuisances, and then put a B and have it say other threats to public health. But I'd also then create a whole new paragraph, Roman numeral 2, that says, if the regulation is related to B, 1B, the select board shall meet in a public hearing to renew any such regulation every X number of days, and I'd be open to you guys. But basically, if they're going to use the idea of a public threat to public health as being a regulatory model, let's give them that authority, but let's make sure it's routinely reviewed. So once the threat goes away, the select board can just let the regulation die without any further action. That was my inclination. If the members like that idea, I'd be willing to draft an amendment to do so.
The original bill that came to us, before I hijacked that bill and put something else on it.
Oh, I remember. SB 154, SB 160.
Had things in there about public hearings and everything else. And that's how we got down to the simpler version. People who are confused by it, I'm sorry, I believe that they're trying to be confused by it. But I don't think we need to go that far. I think that, adding something in there that say, these ordinances are in effect for 30 days, unless approved by the state health officer, would be appropriate, something like that. But I'm not.
I'm just trying to find a renewal process. I'm just trying to find a process that, again, because if it comes up for renewal and the citizens really object, they have a place to go and complain and say, I don't want you to renew this. Don't do that. They have an opportunity to have their voice heard on this rule. They may need the ability to put an immediate order in and have it approved by the selectmen because there is a true threat to public health, whatever that may be. But after 60 days or 30 days, there probably should be a review process to give it more time for citizens to weigh in within that community. That was my idea of doing it. Again, I think for the purposes of nuisances, they don't need to, but if they're going to use the argument of threats to public health, then that should have a review process afterwards, especially given the fact that there are actually no conditions on who can be a public health officer, right? Anybody, your local mechanic can become a public health officer. So the idea that there's further review and have citizen input after a period of time, if you're going to use that argument of threats to public health.
I tend to think we don't need this at all. I think most health officers act in a prudent way. I think we discussed last year many, many circumstances like rodent infestations, spraying for mosquitoes, picking up trash, all sorts of things that require quick action by the health officer. I certainly hear what you're saying. I would tend to agree with the chair that if we're going to make a modification, looking to the state health officer might make sense. But I also tend to believe that we do already have local mechanisms for feedback here. And this might be something where it's much better to just leave it in local control because, I'm sure that Hanover is going to have a different opinion than some other places, and that's okay. And so, I certainly hear what you're saying, but I'd prefer to leave it less complicated so that health officers can put something in effect for 7 days and then it can go away if it doesn't need to stay. It's my 2 cents.
I like the idea of having an automatic expiration date where it's forcing you to look back on it, and I think the chairman mentioned something to the effect that unless this is in line with the state public health officer, I'm not. I'd like to see what you had in mind with that. So I think that I'll hold judgment on that. But I do like the idea of having this forcing that renewal process at certain intervals. And I mean, it's, not only was I surprised at the lack of qualifications that are required, but just the authority that they have. I mean, they've got more authority than any of us here, and even to some extent, only rivaled by the governor. So I think that we need to, I would be interested to see what you had to offer.
Okay.
And I'd be happy to help you out on that.
What I've got written down here is that Lang, and I'll add Roachford. Anybody else want to be added to the list of people who are going to work on that?
Hey, I wouldn't mind working on it. I don't know how welcome I am to the working group, but
We'll let you in the
I'd be
club.
happy to.
The only thing is that we have to worry about quorum. Okay.
Yeah.
So
Sure, we'll figure that out.
I will do it this way. Senator Lang will accept input into this bill from the other senators that wish to provide such input, and will come forward with an amendment in the future.
Sounds
Okay?
good. Thank you.
And that'll keep us safe from having a quorum work on. All right, back to our other bill that didn't get anybody here. So, Claire, others,
Charlie Sinclair.
any municipality that votes to allow within that municipality the issuance of permits for display fireworks, local fire department may inspect the site of the display.
I could.
I guess, yeah.
Yeah, thank you. Yeah, I think this puts the fire department in a bad spot, because if they say no, no, you don't really need anybody present, and something happens, it's on them. And it's a matter of revenue also, that you could get somebody complaining, yeah, I had to put 2 firefighters out here, and I had to pay them X amount of dollars. So, yeah,
My only reservation to that is if I am out on Lake Winnipesaukee and I'm shooting the fireworks off, you know, or shooting them off over the lake. There probably are circumstances where the fire department, Rochester has spent a lot of time with fireworks ordinances and stuff. Especially, you know, the dog owners that are living near where it is and say that their dogs are going berserk during the fireworks. Comments from the rest of you?
Mr. Chair, I move ITL.
second.
L&L.
Rip the Band-Aid off.
Let's get there.
Yeah.
We're all talking about ITL.
Yeah.
No big speech.
Further discussion? All those in favor of ITL say aye.
Aye.
All those opposed? The ayes have it. Motion for consent.
Moved.
Second.
Lang and Rochford. All those in favor of consent say aye.
Aye.
All those opposed? And Senator Lang gets to take it out. All right. We've gone through the bills, previously gone through the other 2 bills that we have pending. Your list of upcoming bills has the dates for most of them, I guess. Oh, the dates haven't been put on that new one. we are going to be hearing 4, 5, and 6 bills, depending upon the week. That will get us done in plenty of time. And if there's any other bills that are going to come over to us, we'll have some time to do them.
Chairman, are you expecting we will meet on May 6th based on your current schedule? I'm just trying to plan some travel and I don't want to miss.
We do have a
bills
meeting
on May
scheduled
6th?
for,
Okay.
and that is, I think, 5 or 6 bills on that day too.
Okay.
Mr. Chair, just to let you know, May 13th, I'll be out of the state.
Okay. I don't have anything scheduled for May 13th.
I'm just saying
yet.
12, 13, and
Yeah.
14, I'm out of the state.
And
Well, our HB deadline
I'm
is.
sure there will be people lining up at the door to replace you if we need a vote. All right. Anyone else for anything in exec section? If you think of anything that you think I should be discussing with Secretary of State, or you want to schedule your own meeting, either contact me or contact the Secretary, and we'll go from there. We have
Move to come out of exec.
I have a motion and a second to come out of executive session. All those in favor say aye. Aye. All those opposed say nay. Our business today being complete, we are adjourned.
Dave, I'll do a rough draft of that amendment. I'll send it over.